I can bring in Professor Marc Weller, Professor of Law at Cambridge University in the United Kingdom. Thank you very much for speaking to us here on France 24 today. How much of a legal basis, if any, was there for this conflict?
There was no legal basis for the initial attacks against Iran. There was no imminent threat which would have allowed Israel and the United States to attack Iran. And there's no other evident legal justification one could put forward. The UN Secretary General has noted immediately that there was no legal basis. Legal experts around the world are pretty much united around this issue. France has taken a position now. Spain had done so previously. And so there is no legal basis for what is at least the initial launch of this massive campaign.
And are you aware of any indications that international law was meaningfully consulted before the US and Israel launched their first strikes last Saturday?
Presumably, no. The United States has recently engaged in other uses of forces, most notably Venezuela, where no real effort has been made to justify the operation. Israel has argued that this is a case of preemptive self-defense, arguing that at some stage down the line, there would have been a nuclear weapons capacity on the part of Iran, and therefore one had to engage it now. But according to international legal standards, anticipatory self-defense really only applies if there's an instant overwhelming threat, leaving no choice of means and no other means to address it other than the use of force. In this case, there was actually significant progress in the diplomatic process concerning the nuclear file in the Geneva negotiations. And again, there's no real legal justification one could look at. In some of the individual countries that have become affected, like France, which has now articulated its position, the British have been quite cautious initially. They ruled out the use of US bases for offensive operations and have now only allowed the United States to use US bases in the context of protecting the Gulf states. The Gulf states themselves have become the victim of unlawful acts of aggression by Iran, and they in turn are entitled to self-defense.
I'd like to go back to the early hours of this conflict. US President Donald Trump saying explicitly that regime change was an objective of this conflict. Is that, or is it not, a clear violation of international law as I understand it?
That too is a clear violation of international law. Regime change is not a legitimate objective for the use of force between states. And you will have noted that both the US president, but also other members of his cabinet, have been kind of wavering in putting forward different justifications, ranging from regime change to self-defense to the defense of Israel or the Gulf states. But none of that really offers a persuasive legal justification. So this is an example where I think the US thinks that Venezuela has shown that you can use force with relative impunity and force works, whereas the rest of the world remembers that war is something which we thought in the 20th century we had learned to outlaw, and that really should only apply in circumstances of genuine self-defense.
And you talked just then about support for this conflict among Trump's inner circle. Congress this last week chose not to limit Trump's powers in this conflict. Do you think that stance could change if this conflict does continue in the short to medium term?
Well, that depends on how it turns out. Many political analysts fear that Iran might end up as Iraq did at the end of the 2003 conflict, which was also without a legal basis, and that the country could be subjected to a prolonged internal armed conflict. You also remember Libya. They still are in the aftermath of the regime change that was obtained there. In the US, of course, the debate is also about war powers. Can the president start a war, an aggressive war, in this case, without congressional approval? And there his majority in Congress has helped him overcome the threat of censure from Congress.
I'd also like to talk about one particularly extremely disturbing event that we've been covering here on France 24, of course, the strike at a school in Minab in Iran at the beginning of the week that killed over 150 people, many children among them. That school being located right next to an IRGC compound. Both Reuters, also the New York Times, say that the US was most likely responsible for that strike. Can you assess the legality of that strike specifically?
Well, obviously, there's the international principle of distinction. Even in a war, whether or not you launched it lawfully or not, you can only target military objectives. I think we would all be persuaded that the US did not set out to attack the school with these horrible, sad results. And they're now investigating whether or not they think they were responsible. But this is a serious violation of humanitarian law, although the US, I think, will argue that they were trying to hit something else and that was not their intention.
I'd also like to talk about the US sinking of an Iranian warship this week off the coast of Sri Lanka. Does attacking a vessel in international waters en route home after military exercises constitute a lawful act of war, even if, of course, we're assuming that the war itself is a legal one?
Well, if the war is illegal, then attacking military vessels of Iran somewhere on the other side of the globe would similarly be unlawful. But more specifically, there's the so-called doctrine of the theater of war, that you would only be entitled to attack the forces that threaten you, that are participating in the armed conflict, and to go after Iranian assets wherever they are in the world would also strain that doctrine. You remember when the United Kingdom sank the Belgrano, an Argentinian vessel in the Falkland Malvinas conflict, with even larger loss of life, that too was very difficult for the United Kingdom because it wasn't clear whether that vessel was actually involved in the conflagration concerning the Falkland Malvinas.
Now, the UN Secretary General has condemned the fighting. We heard a little earlier from a UN spokesperson as well, along similar lines. Is there any realistic path here, do you think, to accountability?
No, the United States rejects the authority of the International Criminal Court. It is unlikely that Iran can mount any significant proceedings against those involved in the conflict. It will not obtain custody over them. And so it seems unlikely that there will be significant accountability attached to it. Perhaps some years later, there may be issues that members of the US government may find it more difficult to travel to states that are willing to exercise their national jurisdiction over potential war crimes. But I think that would be quite far in the future.
And just lastly, Professor, what sort of precedent do you think this apparent doing away with international law, the norms that govern international law, how do you think that that's going to play in the long term?
This is one of the true dangers of the present situation, that this case might prove to some that the use of force is now again a means of national policy, something we thought we had overcome after World War II. To stop that development, it is important that all states reject what has happened and clearly label it as an unlawful use of force. Unless that happened, there will be an unhappy precedent resulting from this. We have already seen some regional states adopting similar rationales for attacks against their neighbors, and this is going to be a very unstable, very uncomfortable world for us all.
Professor Marc Weller, Professor of Law at Cambridge University, thank you very much for taking the time to speak to us here at Around the World on France 24.
Thank you so much.